She is in a jury trial for several days. So you're saying Miss Aaron is going to
Have a
to sit
seat.
in
Have a
custody?
seat. Thank
Okay.
you. Excuse me, I don't understand the attitude. Have a seat. I will take your matter up. I was explaining to you what the issues were. I don't
I'm
know.
not the court-appointed attorney, as you've already mentioned, so
No,
I'll
you're not.
contact Ms. Sawyer.
Thank you. And if she's not here, a warrant's going to be issued for her arrest. From my memory, what I do know is that Ms. Sawyers at first wanted to be withdrawn from the case because she said she was having issues with Miss Aaron's father. You filed a motion to withdraw. There was an issue with Miss Aaron's father interfering in your representation. Your daughter and her attorney need to be able to have conversations in private. You know what? Your child only chose A, B, and C because of you. So we're going to let you suffer the consequences. Hello.
Hello, Judge.
Hi, how are you doing?
Doing good. Nice to meet you.
All right, nice to meet you too. So you're the father?
I am.
Okay. All right. So this is what I always tell parents. And I used to be a defense attorney, so I know how it is with parents. When parents have children, their child can be 30, their child can be 40, that's still their baby, and they want to be involved. And it's especially true when you have a child who is young, 17, 18. But here's the thing, in this world, they're all considered adults.
Okay.
And when they have an attorney or something, the relationship is between them and their attorney. I used to have to tell parents all the time because sometimes the parents would hire me. And I used to have to sit down with parents and say, hey, you've hired me, you're paying me, but that's the end of our relationship. You can't be a part of discussions I have with my client because guess what? I would tell them, if you're a part of discussions I have with my client, then there's no attorney-client privilege. And you know what ends up happening with that? When there's no attorney-client privilege, guess what? You can be called as a witness. Anybody who's in that room having a conversation, it's all fair game. They can be called as a witness. And maybe sometimes there is something that maybe a client wants only their attorney to know, and they don't want other people to know. But when parents are in the room, guess what? That all goes by the wayside. And sometimes we have to let our children go and let our children be adults. So on this side of the fence, I would always tell parents, it's great. I need you to be supportive. I need you to make sure that my client, your child, is keeping their mental health great. They know that everybody is rooting for them and are a part of their team. And I would tell them, but that's where it ends. And it can't go past that because when it does, there's an issue. And let me just tell you my experience with one case I had in the past. Had this client very young. Mother wanted to be 100% in the conversations, even though I would tell them, hey, you shouldn't be in this conversation and you cannot be talking to your child about what happened because guess what? You can be called as a witness. They wouldn't listen to me. And so when it came time to do a plea bargain agreement, the parent is in the hallway, and I can tell you this because they were in the hallway shouting, so everybody heard, so it's not confidential. So they're like, I want my child to do A, B, and C. And you know, I told them, I said, that's your child's choice. Because guess what? If your child chooses A, B, or C, and if something ends up happening and they end up going to prison, the judge is not going to say, you know what, your child only chose A, B, and C because of you, so we're going to let you suffer the consequences. You understand?
I do.
And for some reason, with attorneys, people assume that being an attorney is easy and being a doctor is so much differently. Because if you go to see a doctor and you get a second opinion and a doctor tells you, oh yeah, your child needs a heart transplant, or oh yeah, we need to take the appendix out. A parent doesn't go to that doctor and say, well, I want to look at everything and let me just tell you how I think this appendix should be taken out. The person depends on the doctor, that the doctor knows what they're doing. And that's the same case. That's the same situation with these cases. And everybody needs to understand that. Cannot be crossing lines. Does everybody understand? Understand?
I understand.
All right. So that's the way it's going to be. So this is what's going to end up happening. We are going to come back and we're going to come back on June 27th. Council, is that enough time?
Yeah, yes, Your Honor.
All right, so we're coming back on June 27th, and let me just tell you the way this court is
Oh,
run.
well, you say 27th or 22nd?
27th.
I am double booked. I've got a hearing on the
Okay,
27th, but
all right, we can bring it back on the 24th.
yes, thank you.
All right, so we're gonna come back on June 24th. This is the way things run in this court. I make sure that everybody has the discovery. So when the defense counsel and everybody tells me I've received all the discovery, next thing I do, I require the state to tender an offer to the defense. And the defense has an ethical and legal obligation to tender that offer to their client and tell their client what the consequences are of the offer. Then I give everybody a plea deadline date because I want people to think about whether they want to accept the plea or not accept the plea. If they decide not to accept the plea, when I give them the plea deadline date, then that plea deadline date has expired and the next setting is going to be a jury trial. And if somebody after that plea deadline date has expired decide, oh gosh, I don't want to go to trial, the only way I'll accept a plea is for good cause. Otherwise, they'll have to plea open to the court. All right, everybody understand? Any questions, Dad?
I do have one
Sure.
question, Judge.
Yes.
When your child has a serious, persistent mental illness and a developmental disorder, and that is recognized and should be recognized early on in the Article 1622 of the Code of Criminal Procedure. And there's been multiple suicide attempts.
All right, let me stop you right there. So here's the thing. With regards to that, that is something for her attorney to address. What you should do as a parent is turn information over to the defense attorney if you think it's something that she needs to know or is something that her client wants her to know. You understand? So here's the thing, you got to cut the string. And when I say cut the string in the court, I mean court the card as in your daughter and her attorney need to be able to have conversations in private. Now, if her attorney wants information from you, then the attorney will ask you, say, hey, I need some information from you. These are records. Maybe I need these records. I'm trying to get these records. Do you have these records? This is something that I want to view. That's completely up to the attorney. But what you're telling me right now and quoting code sections to me, guess what that tells me? You're trying to be an attorney and you're not an attorney. Did you go to law school?
I didn't go to law school.
So there's the thing. People think that they can read penal codes. They can read the Code of Criminal Procedure and that's it. And not to step on anybody's toes, but for criminal law, when you're practicing criminal law, you know what your Bible is? Your Bible for your profession is this book. And you see how thick this book is? And so if I were not an attorney, guess what? I would see one section and I'm like, oh, that section says that. D is for done. But that's not the way it works. This entire code, guess what? You may read something in this section and still you have to go to this section because it all relates to it. It's similar to the Bible. And let me bring the Bible up for you. Some people will just read one section of the Bible and guess what? When you read that one section, that same person who is listed in that one section, there's somebody else in a different book that has something about that person in the other section. So when you just come away with one part of that section, you think, oh, I'm done, and you're not. And that's why you have to study this forward and backwards. And how many years have you been an attorney?
Over 20, and I'm board certified in criminal law.
All right, over 20, board certified in criminal law. So when people are throwing code sections out to her, let me just tell you, I know her. Every attorney in here knows her. And all attorneys know each other because when you've been in Bexar County practicing for over 20 years, people know you, people know your work. What I can tell you is She would not be board certified in criminal law if she didn't know this book and know the updated part of the book. And what do you do for a living?
I have been the president of an international Fortune 400 company in
Okay.
Mexico City.
So let me ask you this.
Yes.
How would you feel is if you are doing that job, and how many years have you done that?
20.
You've done that for 20 years. And I just walk into your place of business and I'm telling you how to run things and telling you what the law is about something that you've been doing for all your adult life. Maybe you wouldn't take offense about it, but I guarantee you when I left the room, you know what you'd probably say? Who does she think she is? She doesn't have a degree in this. She hasn't even worked in this field and is trying to tell me how to do it. And for me, that's with any job. For example, I wouldn't go to McDonald's and tell them how to cook their fries. I haven't cooked their fries. I don't know how to cook it. I would not go to a contractor and tell them how to pour concrete. I may think I know how to pour concrete, but the little things I know about pouring concrete, you have to have it at a certain temperature. Otherwise, it's going to crack. You have to mix it appropriately. That's why when you see people out here mixing all their concrete with quick concrete, sometimes it doesn't go right because there are certain things that experience, knowledge, and education treat you about it. So here's the thing at the end of the day. At the end of the day, this is her attorney. From what I've seen, it appears to the court that she's following through on all mental health issues if there are any. You know why I know? Because I put in here, refer to mental health court. And I know that she's been working on doing that. That's why it's in here. Otherwise, it wouldn't be. And you know how I know that? Because she requested it. So when you come to me about the code of mental health, I already know she knows about that because otherwise it never would have been requested.
Judge Mayer?
Sure.
And of course,
As long as you're not quoting the law to me.
I won't go the long, Your Honor.
Okay.
Of course, she did go to mental health and that's where we discussed, and that's the absolute right place to be. Just a month ago during a suicide attempt, I said, I really finally have insurance and I'd like to get inpatient care for her because it's a very, serious issue.
Okay.
And I was correct. No, let's hold off until we can get.
So here's the thing though. The advice that she's given your daughter and the advice that maybe she's given you, that's from her legal perspective. And she's trying to protect your daughter's legal rights because this is a criminal case, right? So that's what's happening. So what we're going to do, I'm sure she probably already has, but I'm sure she'll do it again. If your daughter wants to, she's going to discuss with her what the offer is. And we're going to come back. Either she's going to accept the offer, not accept the offer. And either we're going to be in jury trial or we're not going to be in jury trial. That's where we are. But I will tell you this, whenever you're meeting people and you're meeting people in their profession and you want to talk to them, don't quote them things about their profession. I know that she's not going to take it as a slight, but people tend to not like that because people pay more what the cost of a mortgage for their degrees, and they spend a lot of time, experience, and knowledge doing what they do. And I don't know of any defense attorney who would purposely try to lead their client down the wrong path. And I've never seen her try to purposely lead her client down the wrong path. And just my experience of a judge with her, I've never had to tell her what the law is. Okay. All right. Is there anything else?
There is.
Yes.
My client had a mental health evaluation that her father has possession of and is refusing to relinquish, from my understanding. I would like to get that today.
All right. So here's the thing. I can't force you to turn over things to her, but get this. She needs information in order to represent your daughter, right? So that's what she needs in order to represent your daughter. Whether you want to turn it over or not, that's completely up to you. Here's another thing I would always tell my clients and my clients' parents. This center of the courtroom, which we call the well of the courtroom, is a minefield. Your child, I am directing them on where to walk in this well. That's a minefield. I'm behind protected glass. I'm going to be just fine. But when I'm telling them to turn right, it's based upon all the information that you've given me or withheld from me. And when I tell them to turn right, I would always tell them they have no choice. They're going to go right. Now, when they turn right because of some information you haven't given me, and I'm going by the information that I have, is there going to be an explosion? If there's an explosion and it's because of some information you had that you didn't give me, that's all on you. So if you or if people care about their children, this attorney, it's confidential. So if she receives something, guess what? It's confidential. It's something that she's received. Maybe it's something she wants to discuss with her client or not. It's not something that she is going to turn over to the state unless that's something she thinks should be done. So if you want to hold on to that, then that's up to you for holding on to it. But if you say you want to help your child and she's telling you she needs that information, I mean, what do you think she's going to do with the information? You know?
Well, I would say, I'd love to hear what her understanding of Michelle's mental.
Here's the thing.
Yeah.
I want you to internalize what I'm saying. She doesn't have to talk to you. You're not her client. What she's telling you is you have information and I'm assuming you want her to see the information. So either you want her to see it and study it and give it to her, or you don't. If you don't, that's fine. I can't legally force you to turn that over to her. But what I'm telling you is if this is a child and you say you love your child, which I'm assuming you do, I've just told you the information you turn over to her is information you've given to her. Her medical records are confidential. She's an adult, so I don't even know why you have them in the first place because she is an adult. Those medical records are her medical records. They are not yours. She is not a child in the eyes of the law. So if you have something that would help her attorney represent her better and you love her, you probably should turn it over. The end. That's it. The end. All right. So either are you going to turn that over to her or not? That's either yes or no.
I'm gonna give it to my daughter. If she wants to, it's a client, privilege between the two, and if she wants to.
All right. So just hand that over to your daughter now then. All right. Is there any other documentation that are medical records that belong to your daughter? And when I say belong to your daughter, her name is on it and it's related to her treatment. Do you have anything else?
Not with me.
All right. So this is what you need to do. Again, I can't force you to do it. Her medical documents are her medical documents. And do not interfere with her and her attorney relationship. You understand? So you can't give her her documents and then say, oh, I don't want your attorney to have it, or I don't want this to occur. You need to be a part of her having great mental health. And the way to do that is not put stressors on her. And don't put stressors on her by interfering with her relationship with her attorney. Because guess what? This atmosphere, being on the criminal side, is already stress enough, whether somebody committed an offense or not. Can you imagine the stress that people have because they think maybe they're going to prison? People in the box, guess what? They're over there. They're brought over from the Bexar County Jail, not on bond, can't make bond or something else. Even though you may say, oh, my daughter's not like those people, or my daughter doesn't have criminal history. Guess what? Even if there's somebody over in that box who's been to prison before, guess what? Their heart is still beating fast because they don't know if they're going to go back to prison or not. So this is a stressful situation for her. Don't make it any more stressful. You understand? All right. Thank you very much.
Thank you, Your Honor.
You're welcome.
I reset to the 24th. All communications.
No, this is what we're going to do. I'm going to call. We're going to go on the record. And if she's not here, a warrant's going to be issued for her arrest. And if she gets here within a reasonable time, the court will reconsider. Could I have a prosecutor, please? And could someone make an announcement in the hallway for Claudia Michelle Aaron?
That was gonna make a joke. Looks like I'm the only one.
No. All right. Court is calling 2024 CR 0735 State of Texas versus Claudia Michelle Aaron. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Jody Sawyers for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 9:49 a.m. Defense, have you had any personal contact with your client?
None.
All right. Deputy Laura, did you make an announcement?
Yes, Your Honor, there's no answer.
All right, state.
State would ask for a bond forfeiture, Judge.
All right, that will be granted. Your client will be remanded without bond. If she makes an appearance within a reasonable time, the court will reconsider.
And Your Honor, I just want to go on record as
Yes.
communicating that I did receive communication not from my client, but from her father saying that she has been admitted to Windmill Wellness Ranch. I contacted them this morning. They sent me a letter saying that she apparently has admitted herself voluntarily, although I don't know if it was her or her father who did, for a 60-day program. This was never communicated with me beforehand. And so I approached the court, though, only to let the court know that I have received communications from a rehabilitation facility
Mhm.
and letting the court know that information.
All right, she needed to be here today. And that rehabilitation center, it's the court's understanding that that's not some type of mental health issue where she needed to be admitted, correct?
It was not emergency detention, Your Honor. That's correct.
All right, thank you. Her out. Here's the issue. She retained an attorney. That attorney did not have a motion to withdraw signed. She's still the attorney. And what ended up happening at that hearing is there was an issue where the defense attorney said that the father of her client is interfering with her ability to represent her. But the father ended up turning over medical documentation to the defense attorney. And then that was that. There was no re-urging of the motion to withdraw. And there's nothing in the system that shows, one, that a motion to withdraw has been signed. So if a motion to withdraw has not been signed, that's still the attorney. And correct me if I'm wrong, for the MAC to appoint her an attorney while she has a retained attorney in felony court, that appears that may be interfering with the attorney-client relationship. And then the next questions become, if she was able to afford to hire an attorney, then why is she receiving appointed attorney, a court-appointed counsel? So if you wish to speak to her, you can. But what I can tell parties is I am not proceeding unless Ms. Sawyers appears because she's listed as her attorney of record.
May I address the court?
I mean, no, that's what I've said. So if I'm not proceeding without attorney Sawyers being here because technically that is her client. And I haven't received a motion to withdraw.
Have, and it's on file.
It hasn't been signed.
The order, you're correct. The motion has been signed by Ms. Sawyers. The order has not been signed, but there's a
No.
YouTube video in which your court said that as soon as Ms. Aaron reappeared, you would sign the order. She's here. So we're requesting that you
No.
sign the order.
Ms. Sawyer needs to be here.
She is in a jury trial for several days. So you're saying Ms. Aaron is going to
Have a
to sit
seat.
in
Have a
custody?
seat. Thank
Okay.
you. All right,
I'll
so
let
I'm
you
going to
answer.
proceed with this hearing. Excuse me, I don't understand the attitude. Have a seat. I will take your matter up. I was explaining to you what the issues were. I don't know why people don't understand what I'm saying. I've explained to you what the issues are. You see these attorneys sitting here. I was giving you all opportunity to speak to her so you can understand what the court's issues are. That's where we are.
Judge, we
And
can't
then
get
I'm going
Ms.
to take
Sawyers
this
here.
hearing up and then we'll continue with your matter.
I'm not the court-appointed attorney, as you've already mentioned, so
No,
I'll
you're not.
contact Ms. Sawyers.
Thank you. All right, are you all ready? All right, we're gonna go on the record and state I realize you were not expecting to be here, so
Sorry,
your
Judge.
address is excused, that's fine. So we're going on the record in 2024 CR 0735, State of Texas versus Claudia Aaron. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Christian Vega for the defense.
All right, you're here for a bond?
Yes, Your Honor. Elizabeth Russell, attorney of record, had filed a motion to set bond.
Well, let me ask you this. Because previously I had the attorney of record as Jody Sawyers. Has she filed a motion to withdraw?
I believe there was a motion to withdraw and then Elizabeth filed into the case.
Well, no, I mean, has it been signed?
That is my understanding, Judge. I don't know if that's what reflects on.
All right, so we'll need to find if that's done, because if that has not been done, then Jody Sawyers is still the attorney. So let's figure that out first.
Yes, Judge.
And I'll see if I can look up on my system.
You see that's on us. Good to see you. Judge.
You too.
They don't show that Elizabeth is the attorney of record. Judge, it's okay if I sit.
Yes, it's okay.
Okay. Judge, Elizabeth Russell was appointed on July 17th.
No, but she may have been appointed, but her retained attorney was Jody Sawyers. So unless Jody Sawyers filed a motion to withdraw, then she is still the attorney. And unless that motion to withdraw was signed, she's still the attorney. So my question is, has a motion to withdraw been signed? If not, she's the attorney. And you're saying that Elizabeth Russell was appointed?
Yes, I believe after that motion was granted.
All right, so the first question is whether or not that motion was granted, because if that motion has not been granted, then that is her attorney. All right, so what I do know from my memory, what I do know is that Ms. Sawyers at first wanted to be withdrawn from the case because she said she was having issues with Ms. Aaron's father interfering with her ability to represent her. However, that motion was never signed because where we left off was the father gave Ms. Sawyers, Ms. Aaron's medical records. And then after that, Ms. Sawyers never asked that the motion to withdraw be heard again. So Ms. Sawyers is her attorney. And if somebody has appointed an attorney, then that's interfering and that's unethical to appoint an attorney when she has a hired attorney.
I think that might be the confusion here, Judge. It seems like the dates where she filed this motion on 7/2, and then Elizabeth Russell was appointed after that without any substitution. So
And there can't be a substitution when an attorney has been retained and manager signed counsel. I'm assuming manager signed counsel appointed somebody, or?
I'm not sure, Judge.
All right, so then Jody Sawyers is the attorney of record.
Okay.
So if you want to get in touch with Jody Sawyers and
Yes,
have
I'll see what I
her
can
here,
do.
and then somebody else needs to find out if she's retaining a counsel, then how is she qualified for a court-appointed attorney? Those are issues that need to be addressed, unless we're just giving everybody a court-appointed attorney, whether or not they can afford one.
I'll look into
These are
that.
just questions the court has.
I understand, Judge, and I can look into that for efficiency. Mr. Escobar has indicated that, he'll defer to your judgment on this issue of whether or not she's.
Oh, state's attorney will need to be here.
Okay.
All right.
All right.
Okay, so I'll be here all day.
Okay, Judge. Good, Judge.
So if you all want to get in touch with Jody Sawyers, you can.
We will. Thank you,
All right.
Judge.
Okay, you're good.
See what your shirts are. Does it still say Judge?
All right, thank you.
Yeah, thank you. Got most of the stuff moved, so.
I'm sorry, what?
I got most of my stuff moved, it's just, bottle fell on my foot right as I was.
Oh,
moving the
wow,
box.
awesome.
Yeah, so, yeah, horrible pain.
Well, let me just tell you, LSU lost, Florida lost. But hey, we still can pick things up.
Exactly. All right, Judge, see you later.
All right, thank you. If you'll get them to screen her, but what we'll do is, Attorney Sawyers, we'll hear your motion to withdraw. Someone from the state is coming down right now, so we'll hear your motion to withdraw. And if that motion is granted, then if you could go ahead and have someone screen her to see if she's indigent. And then if it's determined that she's indigent, then you all can appoint somebody, and then I can hear whatever motion you all want to hear. And what Attorney Elizabeth Russell's, this motion for a PR bond is not in the proper format. It doesn't have the proper, it's not presented legally, should I say. So I'm sure the state will have no objection to your doing it orally. Sure. All
Just to
right, so,
clarify,
yes,
you said the defense motion, are you talking about that motion about the PR bond or my motion to withdraw
your motion to withdraw.
was not done properly?
No.
Oh.
Elizabeth Russell filed a motion for a PR bond, and it's not legally before the court. So this is what ended up happening, Attorney Sawyers. You filed a motion to withdraw. There was an issue with Miss Aaron's father interfering in your representation. When we were here the last time, he came forward, tried to be an attorney, and then he handed to his daughter her medical records, which she then handed to you. And then the motion to withdraw wasn't taken up because I think assumptions were made that he wasn't going to interfere with your representation. Then she didn't show up for court, even though she had noticed to be in court. And so a bond forfeiture was issued. And the court said that I would take up your motion to withdraw once she was in custody. And so that's where we are. So in between that time, managed to sign counsel appointed her attorney, which technically is unethical because you are currently the attorney. And so that was interfering with the attorney-client relationship with her. So what we're going to do is if you still wish to withdraw, I'll hear your motion to withdraw. Once I've heard your motion to withdraw, if I grant it, and part of my granting is going to depend on whether or not Ms. Aaron has any objection to your withdrawal. If I grant it, then you will be excused, and then they will have someone interview her for indigency because that was not done either before an attorney was appointed. So that's where we are. So the state is coming down. I'll hear your motion to withdraw.
And just so that the court is aware, I had thought that this had already been granted because Elizabeth Russell reached out to me. And so I apologize for the confusion. I did not realize that I was still on the case.
Mhm.
I had met with Elizabeth and, well, over the phone, we had a teleconference, but provided her a briefing of the case at her representation to me that she was appointed to the case. So I have communicated with her, and the only reason I wasn't there yesterday is because I didn't realize I was still the attorney of
No,
record.
no. It's absolutely not your fault. So that's fine.
I just didn't want you to think that I was intentionally not showing up. I guess it was just a miscommunication, and I do apologize.
Apology accepted, but not needed. I understand things happen. You've never before not appeared before court, and you've always been respectful. And I'm assuming you still wish to withdraw, is that correct?
I think at this point it should proceed, but obviously I haven't spoken with Claudia because I thought it had already been granted at her request.
All right, do you
So
wish to still withdraw or no?
I do wish to withdraw, but I need to hear what her position is, obviously, because I haven't revisited the conversation since I was asked to withdraw the first time.
All right, just give us one moment, okay? Ms. Sawyers has filed a motion to withdraw. State, do you have any objections to that motion to withdraw?
No, Judge.
And do you have an objection to Ms. Sawyer appearing by Zoom?
No, Judge.
All right, Ms. Aaron, do you have any objection to Ms. Sawyer's appearing by Zoom?
No, Your Honor.
All right, do you have any objection to her withdrawing?
No, Your Honor.
All right, and Ms. Sawyers, what are your grounds for seeking to withdraw?
Yes, inability to communicate effectively and breach of attorney-client contract.
Right, and that ability to communicate effectively, is that due in part to Ms. Aaron's father?
In part, yes, but not in whole.
Okay. All right, then the motion to withdraw will be granted to the clerk. Could you hold her motion to withdraw for me, please? All right, then you are excused. Thank you, Ms. Sawyers.
Thank you, Your Honor. Have a good day.
All right, you too. All right, so the next thing that needs to happen is then she needs to see, we need to see if she's indigent or not.
Yes.
And
Judge, pretrial is on their way up here and we're having their spring trial, 17:02.
All right, thank you. And how long would that take?
I'm assuming it shouldn't take more than 10 or 15 minutes once they get here.
All right. All right. So Ms. Guthrie will go off the record. And if you could just be available, they say this is going to take 10 or 15 minutes.
Yes, Judge. Can I have the gentleman's name that just spoke for my record?
Yes, James Bethke, Director of the Managed Assigned Counsel Program.
It's Bethe. First name James,
James.
and he's Director of the Managed Assigned Counsel Program.
Thank you.
All right, thank you.
I'll be here, Judge.
All right, thanks.
You gotta excuse me, I've been working, so
Oh, no problem.
clothes kind of raggedy,
No.
but I'm not ugly.
No.
I want to say thank you. You don't remember, do you?
No.
You remember, right? Do you remember me? I had dreads.
Ah, okay.
You remember?
Yeah.
I just want to say thank you.
Oh, you're so welcome. I really appreciate that. How you doing?
Trying to get in the path,
Mm-hmm.
but it's so overcrowded.
Okay.
And
Well,
I'm
you know,
not-
you just got to keep pushing and stay on the path.
I had Avery Solid dealing with it. Look me up, Lamont Curry.
No, I remember you. Stay on the path. But I remember you with your dreads. Yeah,
And you was
Lamont, I
my-
remember your attorney was Robert Porter.
We're-
Yeah, I remember you. So I'm telling you, you got to stay on the straight and narrow. I'm sure I told you
It's
last time.
overpopulated.
No, it's not.
There's so many people trying to get on the straight and narrow. So I'm like, well,
No,
I
you
might
better
as
get
well-
on there because you know I remember you, and I remember that you had a jury trial. The jury found you not guilty, but here's the thing: with your history, your minimum is 25 years prison. So even though that path is crowded, you better get on it.
How you remember that?
My mind's a steel trap. Why do people think my mind is not? But Sean, they think I'm joking when I say my mind is a steel trap. Your minimum is 25 years prison, and if it's a state jail felony, you're looking at 2 to 20 because you're a habitual. But if it's anything other than the state jail facility, if it's state jail felony, if it's a third-degree felony, your minimum starts off at 25 years. You're not eligible for probation from a jury, and you're looking at 25 years minimum. So you have to ask yourself, staying on the straight and narrow, it's crowded. Do I try to get on that path, or do I get off that path? And it's 25 years of my life worth not being on that path.
I was thinking about jumping off that path.
You better not. Texas does not play. 25 years. And how old are you? Because I never asked you that before. How old are you?
How old do you think I am?
Now, we're not playing those games. This
Okay, 45.
You're 45.
Yes.
If you do 25 years, guess what? When you get sentenced to 25 years, they are not going to release you at half your time because they're going to see that you're habitual. You're probably going to end up doing 20 years flat.
So
And
that
then
I
you'll
could-
be in your 60s. And maybe in your 60s, you'll find the right path because you'll only be able to sit on the front
so
porch.
I'll be walking with a wheelchair or a
Maybe not.
walker,
And then
cane.
maybe, or maybe you'll be in a box. They give you a pine box at a prison when you don't make it out. If somebody doesn't claim your body, they'll give you a pine box and find a place for you. And I will tell you this, the jail, there's overcrowding at the jail, but guess what? They're still open for business. There's overcrowding at the prison, but they're still open for business. So good luck to you.
I just want to say thank you.
Oh,
Okay.
you're welcome. And look, and I just put you back on that path.
Yeah, because you got a vision, put
Oh, I have,
intimidation,
no,
you put everything in my eyesight. Maybe I needed this, but I want to say thank you.
oh, you're
Okay.
so welcome and stay on the right path. And call Robert Porter.
Where he is?
Yeah, he didn't even,
Is he here? He here?
no, he's
today?
not here today, but just call him on the phone. He's in I know they don't have phone books anymore, but I'm sure you can look him up.
Okay. Can I get a dab, Judge?
I don't do daps. They don't allow
Can I
it.
get a peace sign?
Peace. All right. Have a good day.
That's correct, Judge, yes.
All right, and
I'm
Ms.
off-
Russell did not file the motion properly. Not only the content of it, but the fact that she filed it was done improperly. So, State, are you going to have any objection to Mr. Munoz making an oral motion?
No, Judge.
All right. Ms. Aaron, if you'll come down. All right, so we're basically starting at 0 because Ms. Sawyer's, she was just allowed to withdraw. The motion to withdraw was signed. So there's no interference with any other attorney-client relationship because now my understanding is that you've been appointed, Mr. Munoz.
That's correct, Judge. I know that the MAC office vetted her and she does meet qualifications for indigency, and she may have some substance use or mental health issues that we're looking to explore, Judge. So to my understanding that's the case. And I was notified that Ms. Sawyers was previously retained, but did file that motion to withdraw, thus bringing her, Ms. Aaron, up for counsel. Judge, and the public defender's office is happy to step in and represent her in this matter.
All right, we're going to go on the record. Court is again calling 2024 CR 0735, State of Texas versus Claudia Aaron. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Renee Munoz.
And are you Miss Aaron?
Yes, Your
All right, and we do have the court reporter by Zoom. I'm assuming nobody has any objection to the court reporter appearing by Zoom.
No, Your Honor.
No objection from the defense.
All right, Mr. Munoz, you have an oral motion?
Yes, Judge, if I may, with the court's permission, we're asking for a PR bond, first personal recognizance bond. Judge, in this matter, it's my understanding, she does not have a lengthy criminal history. She's of a young age, and it's a nonviolent offense, Judge.
All right, State?
No objection, Judge.
All right, and I understand that she has pending misdemeanors?
Yes, Judge.
And-
I believe 2 of them.
And what are those misdemeanor cases?
I believe it's a resisting arrest, and I'd have to check on the other one.
All right,
No, Judge, the only one I see is resisting arrest. When I look her up, I just cases.
all right,
You know what court that's out of in?
County Court 6.
Just average.
all right. And so what bond amount are you requesting, counsel?
We're asking a PR bond in the amount of $1,000 be issued, Judge.
All right. And State, do you have any objections to a PR bond?
No, Judge.
All right, the court is going to set your bond at $6,000. The court will grant your PR bond. Now, with regards to the fees that are associated with the PR bond, would you like to address those?
Yes, Your Honor, if those fees may be waived, please.
All right, any objection, State?
No, Judge.
All right, there'll be a waive fees. Now we need to address the drug issues. Miss Aaron, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Claudia Aaron?
All right, I'm going to ask you some questions. It's not about this case. So, in the past, and I know it potentially could be current, but for purposes of this case and not getting into the facts of this case, I'm going to ask you about past. So what is your past usage as it relates to drugs?
I started consuming at a very young age to help deal with my mental health.
Okay.
Around the age of 13, I first started consuming
And what did you
but-
consume?
marijuana, and it led up to Xanax abuse and stimulant abuse,
And what type of stimulants?
cocaine and methamphetamines.
And have you ever had a mental health diagnosis?
Yes, yeah.
And what is your diagnosis?
Major depressive disorder, PTSD, and generalized anxiety.
All right. And with regards to, I'm sorry, any other questions?
No, Judge.
Okay. And do you have private insurance or no?
Yes, I do now.
Okay. And with regards to this case and the facts in this case, was there anyone else with her? Does anyone know?
No, Judge.
No one was with her?
No, Judge.
So she was by herself?
Yes, sir.
Okay. All right. It appears to the court that she needs inpatient treatment.
Your
Does she
Honor,
have,
with respect to that, we would ask if she could be scheduled for an interview for potential outpatient first, Judge. It's our understanding that outpatient is a less restrictive setting. And I've done with specialty courts for a little bit, and I've seen the case managers and the judges in those specialty courts talk about starting off with the least restrictive means, and if that doesn't work, to move up to more restrictive means. Namely because if she doesn't need, particularly the assessment doesn't reflect her needing the inpatient, and she goes in there, it could be more damaging than her starting in at less restrictive. So I'm asking if we can get her evaluated to see her level of needs. I'm not a social worker or LCDC or master social worker, Judge, so we're just asking for just her to be vetted through that to see what she may need from a licensed professional. I don't purport to say that I'm a physician or I know anything about chemical dependency use. I try to learn and absorb as much as I can, Judge, but I think that's why the professionals are hopefully there to
All right.
assist her.
Have you been into inpatient treatment before?
Yes, I currently went on June 22nd of this year.
Mhm.
I've been clean off of hard substances since December 1st of 2023, and I've been sober from alcohol since June 23rd of this year.
All right. So you said you went in inpatient on June 22nd.
Yes, Your Honor.
When were you released from inpatient?
I was released on Monday.
So do you feel you need to go back to that facility?
No, Your Honor.
All right. And when you say you were released, did the persons at that facility release you?
Yes, and they have me in intensive outpatient programming at the moment.
All right. And who is that with?
It's with Windmill Wellness Ranch.
And what does that outpatient treatment look like?
It's 3 days a week, any days I'd like, from 9 o'clock to 12 o'clock for the next 4 weeks.
And what do they do?
We specialize on processing emotions and just constant drug testing and just kind of regulating me back to a normal lifestyle instead of like a heavy, intensive inpatient program.
And how often are they doing drug testing?
At the moment, I have one. I don't know how often they'll be doing it for the next 4 weeks.
All right. And this outpatient treatment, how long is it?
It's for the next 4 weeks.
And what if you need more treatment in outpatient than that? Have they given you an idea of what they would do?
Yeah, I could definitely always ask for more time and help if I really am struggling and need it.
All right. Any other questions?
So just one brief question, Judge.
Yes.
So Ms. Aaron, upon you, if you're able to be released on your own personal recognizance, upon you don't have to pay, would you be re-entering that substance facility, the outpatient to get help?
Yes,
And that would be for when again?
the next 4 weeks.
Okay, no further questions.
All right. This is what the court is going to do. The court is going to order outpatient treatment with Windmill Wellness Ranch, and that's through your insurance.
Yes.
And so what I'm going to say then is to be paid by Ms. Aaron. If for some reason something happens with your insurance, let your attorney know, come back to court, and we'll do a different outpatient treatment. And counsel, she's going to have to do a release to pretrial services so they can make sure that she's actually attending.
Okay, yes, Judge, no problem.
All right, so there's going to be outpatient treatment with Windmill Wellness Ranch with treatment classes at a minimum of 3 days per week.
Yes, for 3 hours a day for 4 weeks.
Okay. And there is going to be random UAs,
Yes.
and that is going to be, yes, I know wellness, they're doing their UAs, but these random UAs are going to be through pretrial services, and I'll ask that they waive fees.
Yes, Your Honor, thank you for that, and I'll explain that to her as well. Pretrial services aspect.
And then I'll ask for a referral to Center for Healthcare Services if she has a private provider with regards to that, then she can do private provider. So I'll say referral to Center for Healthcare Services or with a private provider.
Yes, Your Honor.
All right. Is there anything else you need to be successful on this bond?
No, Your Honor.
Defense, is there anything else she needs?
Nothing further, Your Honor.
Okay. And let me just add one more thing. After conclusion of treatment with Wellness Ranch, I'm going to order 120 sober days. I'm sorry, 120 sober support meetings in 120 days. And I will tell you, those are NAAA meetings. Sometimes people are feeling a certain way about doing these. They're like, why do I have to do this? It's so much work. But then what I've discovered and what people have come back and told me is that once they get into the routine of going to those meetings, they really enjoy it because they get a chance to meet other people who are in the same situation that they're in. And then the next thing I know, they're doing retreats with them and it becomes a way of life. So it's going to be 120 sober support meetings in 120 days. All right. And then I'm going to set you to reappear in this court for this case. And let me look at my calendar. All right. We'll come back on October. Let me see, you're 4 weeks. We're going to come back on October 7th. All right. Is there anything else?
Nothing further from the defense, the judge. We appreciate your attention to this matter.
All right. And if y'all will have a B page pulled, because otherwise the fact that I've just said it on the record is not enough. It needs to be in writing. So if y'all will pull that for me and I'll put it in writing.
So I just go to the clerks in the back and ask for the B page, judge, and they should be able to provide that?
Yes.
Okay, will do.
And I'll give you this reset form.
Yes, ma'am. And then I'll have her execute that as well.
All right. And this will be for discovery. So where are we on this case?
Judge, I've been talking with defense, they're trying to see if possible chief is bringing the body of trophy board in this year.
That's correct, Your Honor. We would like to explore the possibility for meeting criteria for El Camino Adult Drug Court on the misdemeanor out of County Court 11. She does have an active misdemeanor case, Judge. And it's our understanding if she does qualify and does successfully enter that program, complete, this felony matter will be resolved in a kind of global resolution, Judge.
So when is that going to be done?
I can go to County Court 6, Your Honor, this morning and ask the referral be sent to El Camino Court, Judge. We're requesting, I did hear another case got reset to November 19th. That's just a little shy over a month. I think if the court could allow us that date, Judge, that we can get the ball rolling, but I can get the referral in this afternoon, Your Honor.
All right, we're going to come back on November 19th.
An offer has been extended, but that includes hopeful participation in the mental health courts. She was previously referred for misdemeanor drug court. However, she did not meet criteria for that program. From the mental health court, we do have Ms. Panesian here.
Yes, please come forward.
Yes, you can come forward, Ms. Panesian, like with the judge's permission.
Because this has been going on since October 7th.
Yes, Judge. Yes, I'm aware. The reason for the seeming delay is that she was referred for the El Camino program, County Court 11, and she went through the process of meeting with them there. However, she did not meet criteria as per the clinicians, so they said that mental health court might be more suitable. So then after receiving that word that she didn't meet criteria for the adult drug court program, we are referring her for hopeful admission into the felony mental health court, Judge. Ms. Panesian is, she kindly came this morning. She's gonna meet with Ms. Aaron to see about her meeting potential criteria, and then it would have to go through the process of potential staffing and the like, Judge. So we do apologize about the delay, but we have been working diligently to get her the help that she needs, Judge. And we're just requesting a reset for that process to take fold. Unfortunately, it didn't pan out with the adult drug court, but we're hopeful mental health court, as her issues seems to be more rooted in mental health, Judge.
All right. Excuse me. How long is this going to take, this process?
With the holidays coming, Judge, she won't come into the program if accepted until January.
It's with the holidays coming up, Judge, and the mental health court does have graduations as
With the
well.
dockets, I only have one docket for Judge Hell on December 20th, and
She's not going to be able to make that docket?
I don't believe so.
It's also, Judge, a little bit of a little tiny hair in the soup as well, is that she does have an unfiled family violence misdemeanor case that the DA's office with the mental health court is looking into too, Judge. So that's unfiled. It doesn't have a court date, but it's seemingly in there, so we'll have to wrap that up. But we're hoping to have all that done for potential admission to January if she does meet criteria, Judge.
Your Honor, may I ask a question for
Yes.
clarification? When will you know whether she is or is not eligible for this program?
First of all, I have to do a screening, which is an hour-long screening. I send in an attorney packet to the DA's office, which is Bianca Herrera, and she reviews it and gives me an answer. Roughly, I guess, maybe a month, 4 weeks. But with the holidays coming out, next week's Thanksgiving. I don't know.
And then additionally, I know that she's gonna have to possibly check in with Bianca with Melly to see about the unfiled misdemeanor case. To hopefully consolidate those into her getting into the program.
All right, Norma. On this case, recall it for January 28th. That's the final plea deadline date. There will be no further plea deadlines after that date.
Yes,
And
Your
then
Honor.
after that, if this case isn't disposed of, your next date is going to be a jury trial.
Yes, Your Honor. We'll work diligently to that end. We appreciate the court's patience.
All right, thank
Thank
you.
you, Judge.
Thank you for addressing appropriately for court. Once you sign the reset form, you're excused. Thank you for coming in.
Thank you.
Have a good one. You too. Hello.
Hey, good morning, Judge.
Hi. So was she accepted in a mental health court?
Yes, Your Honor. We're happy to announce that she was accepted on January 17th. She has her next felony mental health court setting this Friday in the 379th, Judge.
375th?
379th.
Okay.
Yes, 375th. I'm like, where would that be?
All
I
right.
need to see.
So has she officially been transferred there?
I don't believe the case gets, I mean, I think y'all's court doesn't transfer the file over there. I guess, right? Felony mental health court, you guys keep it here and kind of status it, right?
The status here and then, 379 takes care of it.
Takes care of it.
But no, has she already had a appointment there? Does she have a next court date there?
Yes, Judge. It's gonna be this Friday, the 31st. It's her next court date.
Okay. All right, then.
So Judge, oh, sorry. I was just gonna ask that she's been doing really well, Your Honor. She's been attending court. She's been doing outpatient, and now she's gonna be doing mental health court. If we can get a little leave in terms of a status, perhaps maybe halfway through, just to check how she's doing.
Okay. All right. Nora, set this for May 27th.
You said May 22nd,
27th.
27th.
All right, so we'll bring you back on May 27th to make sure everything is still going well. And if everything is still going well, then we'll spread it out even further.
Great. Thank you so much, Your Honor.
All right, is there anything else?
Nothing further with regards to Ms. Aaron.
All right, good luck to you. Thanks for dressing appropriately for court. Once you sign the reset form, you're excused. You're welcome.
Hey, Bob. Yes, sir. I have an off docket.
All right, so she's accepted into the mental health court. Everything is going well.
Yes, Judge, she's been there for the last 6 months, give or take. She just got phased up to phase 3, so she's doing quite well.
Congratulations.
She's been sober now for the last 1 year, so very proud of her for that. And she's on track to graduate in December, Judge. That's the next mental health court graduation. So we're looking forward to having her on that graduation and completing that program, Judge. So yeah, it's very good news, and we just wanted to just let the court know about all the good things she's been doing.
Okay, that is awesome. And I tell you, if I'm here in San Antonio, I will be at your graduation.
Yes, I would appreciate that.
So let's do this. You want to come back in August?
Sure, Judge. That wouldn't be a problem.
What is a good date for you in August? For both of you, really?
It'll be mid to late August. That
Yeah,
work?
whichever.
Mid to late August, Your Honor.
All right, you all want to do August 28th?
Sure, Your Honor, that works. It's fine.
Okay, all right, keep up the good work, okay?
Thank you so much.
Thank
You're
you.
welcome.
Upon doing the reset form, you should be excused.
Yes.
Thank you.
And thank you for dressing appropriately for court.
Yeah.
Go ahead.